welcome to the DeWitt Law Review on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the DeWitt Law Firm anytime at 1-800-DeWitt-Law. That's 1-800-DeWitt-Law, or visit DeWittLaw.com. If you want to get your legal questions answered on this show, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. We are here every Sunday morning at 10 a.m. talking about Florida's legal issues and how they affect you. My name is John Bustecker, and across from me is attorney Moe DeWitt from the DeWitt Law Firm. Moe, how are you?
I'm doing great. How are you doing, John?
I'm good. It is Sunday morning, and I'm feeling good.
Good. I mean, you can't beat a good Sunday like this.
That's true. I mean, you drink some coffee, you eat some breakfast, you hang out listening to the radio with us. I mean, it doesn't get any better than that.
And you get some legal advice.
That's true. Some good
legal questions, I should say.
Some good legal advice, I would say.
Some days.
Okay, all right. So before we get started, Moe, I want you to tell everybody about this cruise giveaway that you're doing. We talked a little bit about it last week, but I think the deadline is June 30th, so there's still time to enter.
Yeah, so we're doing a cruise giveaway. You can go to Just Call Moe with an E. At the top there, you'll see Win a Cruise. And basically, any teachers, or if you know a teacher who you think's deserving of a free cruise, you can nominate them there, and we're going to give away a cruise to a teacher.
That's awesome. What made you come up with this?
Well, I mean, I think being a teacher has become it was already a hard job. I think it's become an even harder job. Obviously during COVID was a very difficult job. And so we just wanted to do something nice and kind of reward teachers and hopefully get them a little rest and relaxation so they can go into the next year refreshed.
Yeah, it's pretty simple. You just go to justcallmo.com. There's a little tab on the top, and it says Win a Cruise. You can click on that. It's a really simple entry form. There's a little portion there where you can write a small essay about the teacher just to give us some background here on who they are and why they may deserve a cruise.
Yep, absolutely. It's right there, justcallmo.com, and that'll be up to the at the end of the month, and then we'll pick a winner and make the announcement.
Yeah. All right. So before we get to listener questions, and as I said earlier, if you have those questions, send those to ask@DeWittLaw.com. We actually have a lot of questions this week, but before we get there, I want to talk a little bit about ChatGPT and how it is affecting the legal community, Moe.
Yeah, well, you may have seen this story. There was a lawyer, I think it was up in New York, who was using ChatGPT to basically do legal research or, to file motions or something like that. But the problem with ChatGPT, and this is well known in the legal community, I'm not sure why he didn't know this, is that if you ask it legal questions, it will make up answers.
Yeah, and we should explain a little bit. If you don't know what ChatGPT is, it's sort of an online artificial intelligence,
right?
And you can type in questions, kind of any question, write or a statement, write me a 500-word paragraph about the DeWitt Law Firm, and it'll spit it out in 10 seconds sometimes.
Right, and so I heard somebody describe it as it's very authoritative in the way it writes, but the content isn't always there. So that's where you have to be careful. Is it will literally just make up content. So these lawyers filed all these motions citing this case law and citing quotes from the case law and didn't go back to check to see if it was actually legitimate.
That's no good.
No. And so, as lawyers, we're always supposed to check our case law. So, used to have case law textbooks, right? You go down to the law library and open the book and all the case law would be there, and you would photocopy it and go back and do your citations.
When was this, 1950, Moe?
It really wasn't that long ago, actually. But like 10 or 20 years ago, that's, really what people did.
Yeah.
Now everything's online. Basically, we have LexisNexis and Westlaw that are online, and you go on there and you can pull the case law, but you still have to make sure the case law is good because case law does get overturned. So as attorneys, it is part of our duty to make sure that the case law is still up to date and hasn't been overturned by subsequent case law. And you may remember, I think it was the O.J. Simpson trial. I could be getting this wrong, but I think it was Marcia Clark in that trial presented case law to the judge that had been overturned, and she got, the judge kind of called her out for it. So checking your cases is nothing new. This is just kind of an extreme example of it that not only was the case, it wasn't just overturned, it never existed.
So the Chat GPT just made up the cases out of thin air?
Yeah, there's a term for it. I can't remember it.
A fraud? Is that the term?
Well, to some degree, but basically with ChatGPT, if it doesn't know something, it creates it. So it like searches the database, and then if it doesn't know something, it just kind of fills in the gaps, right? So if you ask it, what's my legal remedy if I slip and fall? It will give you the legal remedy, but then if it doesn't know part of it, it just inserts something.
Really?
So that's why you have to be careful of what it's actually saying.
Isn't there a character on Saturday Night Live that John Lovitz used to play where he just like, yeah, that's the ticket. You just make up lies?
Right.
Okay.
Basically.
Kind of the same thing.
Yeah. So this lawyer thought that ChatGPT knew what they were doing. And then I guess they kind of doubled down on it and filed an affidavit saying, no, these cases are real. I got them from ChatGPT. And then obviously didn't look real good to the court. So there's a sanctions hearing coming up. It'd be interesting to see what the judge does with that. But, and I think there was a judge in Texas who recently issued an order saying that you have to check all case law citations generated by artificial intelligence.
Yeah, it doesn't seem like somebody would have to say that, but I'm sure this is happening in the legal community, and not just the legal community, that a lot of people are using this software and this artificial intelligence in their daily lives and in their businesses.
Yeah.
And I mean, I'll say I've used it, and it can be great. Like, it can really sort of save time, but you do have to kind of go back on the back end and double check that the computer is saying the right thing.
Right. It still has its limitations, right? So you can't just, dump all your work on it and expect it to do a good job. There's still a reason that there's trained professionals and people who know what they're doing, and you still have to check it and go through it. But obviously a very embarrassing incident for this lawyer. I don't know if he's just not tech savvy. He did say it was his first time using it. Which
maybe the last.
Maybe the last. You would think if it was his first time, he would actually go back and check it to see if it made correct case citations or not. But I guess it's a good learning experience for this individual. But I just thought it was an interesting case. And like I said, we'll see what the judge does with it as far as the sanctions are concerned.
So when you say sanctions, like, could he get disbarred over something like that?
Well, the judge can't disbar him, but they could refer him to the New York State Bar in this case to further investigate the situation. They could fine him. They could make him write an apology letter. They could make him take an education course, something
just
along
get Chat GPT to write that apology letter.
Hopefully he's learned his lesson on that. So obviously very embarrassing for this individual. We'll see what happens with
okay.
that.
All right. Well, I mean, this is what's going to happen with new technology. I mean, people are going to try to use it and take shortcuts, but you can't do that. You gotta do at least a little bit of work on the back end to make sure your stuff is correct.
Yeah, and the good news is at least my job hasn't been replaced by ChatGPT.
Not yet.
So, not yet. This guy tried to replace me with it, and he got kicked to the curb.
Wait till we get enough recordings of your voice, and then we could just do ChatGPT/AI on the show here, and I'll just be talking to a robot the whole time.
Maybe that's what's going on right now.
Could be. All right, Mo, you want to answer some legal questions?
Sure, let's do it.
Okay, so on the show we answer legal questions. I say you answer the legal questions. I'm just the funny guy over here asking the questions. But if you got questions, send those to ask@DeWittLaw.com. We will try to answer them on the air. This is the first question.
Okay.
I'm not going to put a name with this because it has to do with divorce, so I don't want anybody hearing it that might be involved in it. But here goes. Here's the question. I would like to know what an estimated alimony payment would be after 20 years of marriage and how long that payment would take or last. The rest of the question is, I make $18 an hour while my spouse makes $30 an hour. He doesn't think he should pay any longer than a year or so, and I certainly don't feel like that's fair. What do you say, Mo?
So obviously we have to talk about the new alimony law versus the existing law. So under the existing law, if you're married over 17 years, there's a presumption in favor of permanent alimony, which is basically alimony until the other side, the side that's paying, retires or has a legal right to retire. So that's probably longer than 1 year. Now, you still have to show need and ability to pay. So you have to show that the person receiving alimony has a need and the person paying has the ability to pay. So if there's a big income disparity, that's really what's going to determine whether there's alimony to be paid or not. But when we're just talking about the length, if we're looking at the length of the marriage under the old law, at least if you're over 17 years, there's a presumption in favor of permanent alimony. Now, if this new law goes through, then permanent alimony would be wiped out. But still, under that, I think it's either 50 or 75. It's durational alimony, which just means alimony for a duration, but it's still going to be much longer than a year. You're probably looking at, what they said was 20-year marriage. So
Yeah, 20-year marriage.
So probably 10 to 15 years of alimony. But again, I need to know the individual's age. If he's 60, if the person paying is 64, then maybe only a year is appropriate because maybe he's about to retire. It just depends on their age and, again, the income disparity to kind of make that determination.
And that new alimony law is supposed to go into effect July 1st.
Correct. Yeah, it's supposed to go into effect July 1st, and we'll talk about that some more in detail. But, yeah, and it will go into effect for all cases that are filed after July 1st, but also pending. So if you have a case pending right now, if it's still pending after July 1st, the new law will apply to you.
Is there a way to estimate alimony payments? Or is there like a percentage, or how does that work?
So there's no formula in Florida, but there are some online formulas that you can find. We actually have one on our website. Admittedly, it's a bit outdated at this point, but it was created by a group of attorneys called the American Academy of Matrimonial Lawyers. And so they came up with this kind of formula that estimates alimony. It's not really accurate. It's just kind of a real ballpark idea. The problem with that formula is the tax law changed, so it didn't account for the tax law change that occurred, I don't know, 3 or 4 years ago now. So it's not the best estimation, so to speak, but there are some guesstimators, I should say, out there. But under Florida law, they still have to look at need and ability to pay. They follow the statute. There's no strict formula at this point.
All right, Mo. Next question for you. I'm curious if it matters who files first in a divorce. And does it matter how many years I've been married?
So the who's filed first question I get all the time, actually. It's actually a pretty common question. And it really does not matter at all. The only difference it really makes is whose name's at the top of the paper. So because the courts don't want to race to the courthouse and whoever gets there first, wins something or has some sort of advantage. So there's really no advantage at all in filing first, other than, like I said, your name's at the top of the paper, the other person's at the bottom. That's about it. Now, they asked about the length of the marriage.
Yeah, does it matter if I'm married 5 years, 6 years, 7 years? Like, is there like if you're married 7 years, something happens, and if you're married 5 years, something different happens?
So yes and no. I mean, anything that's acquired during the marriage typically is split 50-50. It's equitable distribution. Most of the assets are going to be split equally if they were acquired during the marriage. As we've talked about before, there's some exceptions to that, but that's the general rule. Now, where the length of the marriage becomes more important is alimony, obviously. So the longer you're married, the likelihood of you receiving alimony, again, if there's an income disparity, if there's need and ability to pay, increases. And usually the longer you're married, the longer you're entitled to alimony. So that's where that's where the length of the marriage really starts to come into play. But otherwise, it doesn't really matter.
What if it's less than a year, though? Does that matter?
I mean, we've had short-term marriages before. I've had people get divorced after 30 days.
I'm thinking of some of those Britney Spears marriages.
I mean, those last like a day. So, there's a difference between annulments and marriages, but, typically on a short-term marriage, you're not going to have any assets. There's not going to be any real entitlement to alimony. It should be more of a simplified divorce in most cases, unless there's some sort of extenuating circumstances there.
All right, Mo, I got one more question. We got to do this one pretty quick, though. All right. I received a ticket going 9 over in North Carolina, and I'm insured in Florida. Will the ticket impact my insurance at all?
Maybe.
All right. No, we got a little bit longer.
So, there is a reporting database where, that your ticket in Georgia will get reported back to, on your Florida driver's license. It could impact your insurance depending on your driving record. What that looks like. Sometimes if it's a first offense, depends how fast you're going, how many points it would be, all that kind of stuff. But it's not like just because you got a different state, it doesn't apply here.
Okay. The states sort of talk to each other a little bit.
Exactly. Yeah. There's an interstate compact where they share that information.
But going 9 over, I mean, let's just say this is just like the first offense or it's been a long time. 9 over is generally not something that would probably get a lot of points on a license because it's probably not reckless driving.
Right. It's not something that's, reckless driving or DUI or excessive speed. I mean, it's just a general speeding ticket that we probably all had. So it's it should be fine. You may want to look at whether it's worthwhile to take one of the classes or something like that, so you don't get the points on your license. But that's just something you have to look into.
All right, Mo, we got to take a quick break. If you got questions, send those to ask@DeWittLaw.com, and we'll be right back.
I'm attorney Mo DeWitt, and I want to send a teacher on vacation. Not with me, but on a cruise for you, to get out of the classroom and have some fun. If you're a teacher, or if you know a teacher who you think needs a free cruise, go ahead and nominate them so we can take them here, here, or here. Being a teacher can be tough, and that's why we want to reward you and send you to set sail on the high seas.
Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on this show, we talk about legal issues in Florida and how they affect you. I'm John Bustecker. I'm here with attorney Mo DeWitt of the DeWitt Law Firm. If you have legal questions, send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. You can always call the DeWitt Law Firm at 1-800-DeWitt-LAW. Mo, are you ready for some more questions?
Always.
Always? You're like a walking encyclopedia.
Oh, they just prop me up at this point and make me regurgitate information.
I don't think we've ever stumped you on this show, have we?
Oh, I'm sure they have. Honestly, if I don't know everything, and if there's something I don't know, we'll say, hey, we'll look it up and get back to you, or we'll do some research, or point you in the right direction.
Okay.
It's all about trying to help people and figure out where to go. But I certainly don't know everything. I'm not going to proclaim that by any means.
All right. Well, good. Well, but you do know a lot. We'll say that.
I think so.
Okay.
I've been doing this a little while.
All right, Mo, here we go. This one's a little bit of a long question, so bear with me here. I was notified by a life insurance company that my ex-husband passed away in 2021, and I was the sole beneficiary. I contacted the insurance company in March 2023 and was told I had to file a claim. I live in Florida, and I traveled to New York City to pick up the death certificate and sent it to the insurance company. On May 15th this year, I inquired about the claim and was told it was denied. They said they mailed me a letter dated May 5th, and I had 30 days to appeal. What should I do?
So we have to unpack this a little bit. So this is an ex-spouse's life insurance policy.
Yeah.
And so it sounds like she was the named beneficiary on that policy.
Mm-hmm. And he died 2 years ago.
He died 2 years ago, and they got divorced before he died.
Yes.
And so that's all very important because a number of years ago, it's probably 8 years ago at this point, there was a statute passed in the state of Florida where if you had a spouse and you got divorced and they were listed as a beneficiary on a life insurance policy, if they were listed as a beneficiary on a 401k or IRA or any of those types of things that would kind of automatically pass, they're automatically disavowed from that policy. So the purpose of that being that somebody didn't, kind of accidentally get a windfall because you just forgot to change the beneficiary. And that had certainly happened before. So, once that divorce is finalized, even though she may be listed on this life insurance policy under Florida law, she's automatically removed pursuant to statute. And so that's why it's important if you do go through a divorce, and sometimes we use life insurance in a divorce to secure an alimony obligation or a child support obligation so that if the paying spouse passes away, that the person who's receiving the alimony or child support will kind of get a lump sum to offset that loss of income. And so when you do that, you have to reaffirm the beneficiary after the divorce. So in this case, if he never reaffirmed her as the beneficiary, and there may or may not have been a reason for him to do that, but if he did not do that, then she's no longer the beneficiary pursuant to statute.
What if he lived in New York, so does the state law matter up there compared to down here?
Well, it would depend where the divorce took place. I'm assuming the divorce took place in Florida just because they're contacting us. So if it took place in Florida and then he moved up there, it may also depend on where the policy was issued from. So if it was a Florida policy versus a New York policy. So really, I think that's probably what's going on here. I'm just kind of speculating, but I think that's probably what's going on here. But really what you have to look at is what's the basis of the denial. Obviously, they've looked at this and they've denied paying out on the policy for some reason, but you need to know what that basis is. And we're not really privy to that information in this letter. But certainly you want to take a look at that. And if it doesn't make sense, or if you need more information, you want to file an appeal and then possibly file a lawsuit if necessary. But I'm guessing that she probably was not reaffirmed as the life insurance beneficiary, and that's why they're denying the policy at this time.
All right, Mo, we got to take a quick break.
Okay.
We'll be right back. If you got questions, send those to ask@DeWittLaw.com, ask@DeWittLaw.com, and we'll be right back. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on this show, we talk about legal issues here in Florida and how they affect you. I'm John Bustegger. I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have legal questions, we answer them right here on this show. Send those questions to ask@DeWittLaw.com. That's ask@DeWittLaw.com. And you can always call the DeWitt Law Firm at 1-800-DeWitt-Law or visit the website, DeWittLaw.com. Mo, how you doing?
Doing well.
All right. How was your break? Did you have a good break?
Got some water. I'm good to go.
Good. I want to follow up on what we were talking about before the break.
Yeah.
We were talking about a life insurance policy from an ex-husband and a woman who she was the beneficiary of the life insurance policy, but she was having some issues with the company. They denied her.
Right.
And so we talked a lot about that, but I had a question. So if she was denied and is denied, and that's their final judgment, the life insurance company, what happens to the money?
So it'd be distributed what we call kind of per stirpes or pursuant to statute, where it basically goes to your heirs in the same way any other assets would. Or it could follow your will if your will said something otherwise. But that's where, they basically have to put the money back into the estate. They have to open up a estate. The life insurance company pays the money into the estate. And then ultimately the court makes a determination as to where the money goes.
So like somebody who may not have kids or anywhere to any heirs, like could it eventually come back to the ex-wife or not?
Probably not. There was a case where I was talking to somebody and they were I guess for lack of a better term, longtime girlfriend of an individual. They were together for like 20 years, but they never got married. And the person kind of suddenly passed away, had no other family members, no heirs, no children, really nothing except for this person who they lived together for 20 years. And he had life insurance, and they could not get the life insurance paid out to anybody because he did not put her as the beneficiary. That was the first problem. So it had to go through the estate, and ultimately, those funds went to the state of Florida.
Oh my gosh!
Because there's nobody to pay him to, essentially. So that's what can happen if there's no heirs. But typically, an ex-spouse is not going to be listed as an heir pursuant to statute. They're going to look at other family members.
So 2 lessons maybe out of this question. 1, check your life insurance policies and who they go to, and if you are somebody who got divorced and you do want your ex-spouse to get the money, update that if you live here in Florida. And number 2, make sure you have a will. I know a lot of people talk about that, but it's important to have an updated will. Even if you're in your 30s, 40s, 50s, 60s, some people don't think about it. I'm going to die one day, but it's going to be a long time from now. But things can happen.
Yeah, it's not something anybody ever wants to think about. And, frankly, it's not something we do in our office. But if you need help with it, we'll certainly point you in the right direction. But yeah, it just makes things a lot simpler for your family members and the people you want to make sure are taken care of to make sure they don't run into issues down the road.
All right, Mo, I got a question for you.
All right, that's what this show's all about.
This is from Sandra P. She's from Tampa, so maybe she heard the show driving through Orlando or something like that.
Or listen to it on the podcast.
It's possible. If you missed any episode, they are up on Apple Podcasts. Just search for DeWitt Law Review, and you can subscribe there. So here's the question. My ex-spouse moved out of state, but I live in Florida with our kids. What factors does the court consider when making child custody decisions?
All right. So break that down for me.
She lives here in Florida. Ex-spouse moved out of state.
Okay.
What factors does the court consider when making child custody decisions?
So there you'd be looking at a long distance parenting plan. So as we've talked about before, the main thing they're going to be looking at is the best interest of the child or the children. But when you have a spouse or a parent who lives more than 50 miles away, so that's kind of the statutory basis for a long distance parenting plan, is if one parent lives more than 50 miles. It's not 50 driving miles, it's 50 miles as the crow flies. So kind of you draw a straight line. Then, typically if you're asking for permission to move, you have to file a petition for relocation, which we've done some shows on before. But at the but if you've already moved, then they're going to have to do a long distance parenting plan, which basically means in most cases, when you have school age children, that one parent becomes the school parent and one parent becomes kind of the summertime and holiday parent, which can be tough because it kind of puts a lot of the responsibility on one parent and kind of all the fun on the other parent. But there's really no other good way to do it, just because you can't have a kid who goes to school, 1 week in Florida and 1 week in Alabama.
Yeah.
That's not
Doesn't work that way. Yeah.
That's not in their best interest. So that's typically kind of what you're looking at. And then, as far as what the court's going to look at, they're going to evaluate kind of ties to the community. Have the kids, been in Florida or been in this area for an extended period of time? Do they have extended family members here, friends here? Have they, kind of built a community? Do they have a support system? How are they doing here? So typically the courts don't want to uproot a child from their life if they're, being successful and they've been in the area for a long period of time, unless they feel that it's going to substantially benefit them somehow. So sometimes one parent may get a really good job in another area, and maybe that's the only place in the country that they can get the job. I said Alabama. Maybe they got a job with NASA based in Alabama. That's the only place they can go.
I used to live in Alabama.
Job pays a lot of money, and so they asked the court to allow them to relocate with the kids there. And maybe the other parent doesn't want to go to Alabama, but the court can grant that relocation. And then it's up to the other parent whether they want to stay here and be a long distance parent or move to Alabama and be closer to their kids. And so those are tough cases. I mean, that's a tough decision for a judge to make. It's a tough decision for a family to make even. But they are tough cases, but obviously it's there for a reason. There are reasons and legitimate reasons where relocations need to be granted, or people would, live further away from each other. And so, those are the types of things that the court's going to look at when they're making those determinations.
All right, Mo, next question.
All right.
This is from Diane. She actually lives in Jacksonville, so maybe she listens on the podcast too.
All over the place today.
That's right. That's fine. That's what we want. If you live in Florida, we'll answer the questions, or you'll answer the questions. Here we go. I was involved in a car accident and suffered severe injuries.
Okay.
How long do I have to file a personal injury lawsuit in Florida?
Okay. So you used to have 4 years to file a lawsuit. Now let me back up for a second. You never want to wait 4 years or 2 years to file a lawsuit. If you're injured in any sort of situation where you think you need a lawyer, you want to contact that lawyer right away, because evidence disappears, right? Cases don't get better with time typically. And if you wait, a month, a year, whatever it may be before you contact a lawyer, a lot of evidence is going to disappear. So, I mean, nowadays there's cameras everywhere. So, anytime there's an accident case, the first thing we're looking at is there video footage of it? What kind of video or photo documentation do we have? Because that's the most powerful type of evidence that there is to document your case.
And we tell people that's the second thing you should do when you get in a car accident. First thing, call police, call emergency if you need that, emergency technicians. Number 2, take photos if possible.
If possible, yeah. If you're too injured, don't take photos, obviously. But yeah, so evidence disappears quickly. There's also limitations with if it's a car accident with your PIP or your no fault benefits. As far as you have to go see a doctor within 14 days to kind of activate those to be able to use those benefits. So there's a number of reasons why you want to act quickly rather than waiting. But as far as the question's concerned, the statute of limitations used to be 4 years for most regular car accidents. I'm not talking about cases that involve federal vehicles or anything like that, but most car accidents in the state of Florida were 4 years to file a lawsuit. Now that the law got changed this year, it's now 2 years, but that's not retroactive. So if you were in an accident that's covered under the time period, you may still have 4 years, but again, don't wait, don't risk it. just assume it's 2 years, but again, act as quickly as possible.
All right. That's good advice, Mo. It's like you've been doing this a while. It's like you've been doing this for some time.
Not my first rodeo.
Well, I mean, the DeWitt Law Firm is celebrating its 25 years in business this year.
Yeah, which is pretty crazy.
You were an infant when you started this law firm.
Not quite an infant.
All right, Mo. Next question. This is from Jennifer. She lives in Maitland. So
right around the corner.
Right around the corner. Here we go. I recently purchased a home only to discover a significant plumbing issue that was not disclosed. Can I sue the seller for non-disclosure in Florida?
So typically, when you purchase a home, there is a disclosure sheet. And if you can show that the seller knew or should have known and basically intentionally did not disclose the information, then you can sue them. Where these cases can get a little tough is, number one, you have to show that they knew about the defect to the home, right? So if it's a hidden defect, if they own the home for 5 years and hey, everything worked fine when they were there and they just sold it and it crumbled the second you moved in, they're not liable, right? So you have to show that they intentionally did not disclose the defect. And so obviously if they had, work or repairs done, if they hired a contractor to fix it or look at it, if they got estimates for it, that's all stuff that can be used to show, hey, you actually had knowledge of this defect and you failed to disclose it to us. The second issue can be collecting on a judgment. So let's say you sue them, you get a judgment for $100,000, but then you have to go collect on it. If they don't have any other assets besides the home, which is going to be protected under Florida's homestead statute, it could be difficult to collect on that judgment. So those are the two things you have to kind of look at with these types of lawsuits. A lot of times, especially when you're thinking or contemplating about this type of lawsuit, you may not even know, or you really don't know whether the seller intentionally did not disclose it, right? Because of course they're going to say, well, we had no idea. And so then you have to go digging and try to find some proof of it. Maybe depending on the situation, if this was a sewer situation, right?
Plumbing.
If you talk to the neighbors, maybe the neighbors say, oh yeah, they have plumbers over there every week. They always said that they had problems. And maybe that tips you off that they knew about this. But otherwise, it can be kind of tough to know about. I've had people come in before where they were opening up a wall for renovations and they discovered just tons of termite damage.
Oh, that's no good.
But the people who sold them the house didn't ever have any, that we know of at least, and that these people know of, didn't have any issues with termites. It was probably the owner prior to them or maybe even prior to them.
All right.
So it'd just been inside the wall forever. And then they had to, and it wasn't live. It was just that they had to go in and really do a lot of work once they opened up the wall because a lot of the beams had to be replaced and things like that. So it was a lot of extra money. But there, because the prior owner really had no idea, it wasn't an open, obvious defect. It was hidden behind the drywall. They really had no claim there. But, it just depends on the individual situation.
Is that one of the reasons to really sort of find a good home inspector before you buy a house? It might cost a little more to get somebody who's going to really go through it, but it might save you money in the long run.
Yeah. I mean, no home inspector is going to be able to find everything, right? But a good one will, probably find some issues here and there and can make you aware of those. And then depending on the issue, you can decide whether you want to move forward with the purchase of the house or not. Now, sometimes, at least with me, the home inspectors always scare me, and then I get nervous. Do I want to buy this house with all these issues? But usually it's not that bad. But yeah, you just have to kind of be prepared for that. But that is the purpose of a home inspection, is to do your research essentially and see what you can find.
You know what scares me, Mo?
What's that?
When those home inspectors crawl underneath the house. I watched one do that and was like, I'm not paying you enough because I ain't going underneath my house.
Yeah, I wouldn't go under there either.
Snakes and rats and all kinds of things.
Who knows what's down there?
Who knows? All right.
Raccoons?
All right. This is from Richard. He lives right here in Orlando. I believe I was a victim of medical malpractice. What are the first steps to filing a claim?
Well, medical malpractice is a little bit different. And if you have a medical malpractice claim, first, you don't want to do it on your own. You're probably going to mess it up. So you want to hire an attorney who's experienced in medical malpractice claims. And they're different because unlike a motor vehicle accident or a regular personal injury lawsuit, you have to go through a whole pre-suit process. And it's very specific in the state of Florida. And if you don't do it properly, your lawsuit can be dismissed. So basically, I'm going to kind of summarize here for the purposes of brevity. But basically, you have to go and hire a doctor who's a specialist in the same field as whatever the individual who allegedly committed the medical malpractice is. They have to review all the medical records and basically sign an affidavit that they believe the standard of care was breached in this situation. And then you have to basically put together a demand package with that affidavit. There's sometimes a pre-suit mediation that may be attended. That's an option. You have to make sure that's sent in a certain way to the person you're pursuing the claim against. And if you don't do all that properly, when you then file the suit, your lawsuit can then be dismissed. And medical malpractice has a 2-year statute of limitations, which is a fairly short statute of limitations because, oftentimes by the time you kind of realize the severity from this situation, again, depends on the case, you may not have a whole lot of time left to file the claim. And medical malpractice cases can be complicated. They can be lengthy. They can take a number of years. So you really want to deal with a professional who knows what they're doing there.
All right, Mo, we got to take a break.
All right.
Don't go anywhere.
I can't make any promises.
I'm talking to you and the audience.
Oh.
Both of you, don't go anywhere. We'll be right back. Welcome back to the DeWitt Law Review here on WDBO 107.3 FM and 580 AM, Orlando's News and Talk. Here on the show, we talk about legal issues in Florida and how they affect you. I'm John Bustecker. I'm with attorney Moe DeWitt of the DeWitt Law Firm. If you have legal questions, send those questions to ask@dewittlaw.com. That's ask@dewittlaw.com. You can also call the DeWitt Law Firm anytime at 1-800-DeWitt-LAW or go to DeWittLaw.com. Mo?
Yeah. Or you can also leave a voicemail for the show.
Oh, what's the number on that one?
407-536-6737, which happens to be 407-53 Moses.
Oh, 53. Why 53?
It was what was available.
Okay. All right. I thought you were going to have a good story there.
No, there's no stories.
All right, Mo. We're asking you, we're grilling you on legal questions today.
It's been rough in the hot seat today.
Is this what it's like to try to pass the Florida bar?
That's completely different.
Really?
I've blocked that out of my memory at this point.
Okay. You did pass, though, right?
I did pass first time.
Okay. That's good.
Yeah.
All right. That's kind of bragging, but that's okay.
Sorry.
All right, Mo. Here we go. This is from Anthony. He lives in Daytona Beach.
All right.
You been to Daytona Beach?
Of course.
Yeah. It's the world's
Down the
most
street.
famous beach.
So they say.
You been to the Daytona 500 ever?
I don't think I ever have.
You should go.
All right.
You want to go?
Let's do it.
Maybe we do a live show from the Daytona 500.
I've landed at the Daytona Beach Airport, which is right next to the track there, which is kind of cool to see.
It's an experience to go to the Daytona 500.
Okay.
Mm-hmm. All right, here we go. This is from Anthony.
We'll do a live show from the 500.
It might be kind of loud.
Nobody will be able to hear the show, but
all right, here we go.
For us.
Here we go. My neighbor and I have a disagreement over the property line.
Okay.
How can we resolve this legally in Florida?
Well, before you could get into a lawsuit, obviously.
They're going to say a duel.
Hopefully we stop resolving our issues with duels at this point. But you could get into a lawsuit. I mean, the much easier way is just to hire a surveyor to come out and survey the property. Now, if there's a dispute between two surveyors, then you may have to file a lawsuit and ultimately have a court resolve it. But usually they can kind of figure it out from a survey as to what the property line dispute is.
Okay.
Now, I will say, that sounds somewhat simple. I've had cases before where people get the property surveyed and the neighbor just refuses to acknowledge it essentially and says, well, I don't agree. And so there you may have to, file a lawsuit against them basically to enforce it. And basically have a court, ratify it and then, basically file a court order restraining them or restricting them from blocking the property or coming on the property, putting fences up on the property. That's the common one. Things like that.
What if the fence is already there? Let's say I have a fence already installed and then my neighbor says, well, I own a foot of your property. You need to move your fence. That That seems a bit drastic. It's expensive to put a fence in.
Yeah, but if they put it in the wrong place, you may have to do it depending how long it's been there. If it hasn't been there for 20 years or more, then you may have to move the fence at that point. So, and there's been a lot of, these are always fun cases for the news to cover. But there was a case where they put the swimming pool in the wrong place.
Yeah, it was right here in Orlando.
Was
They
it?
put a fence right through the swimming pool.
Yeah, they put a fence right through the swimming pool. There's been all sorts of crazy cases. There was a case where a guy had an easement to get into his property. There's a road that had an easement, which gave him access to his property. And one of the neighbors just unilaterally decided that he didn't believe the easement existed and put up a fence.
Wow.
And the guy had to walk to his property every day. This guy was like 65. He was a farmer, but he had to walk. He had to walk his groceries in. He had to, and there was no legal justification that there was not an easement. There was clearly an easement. And ultimately, they had to get the courts involved, and fence came down. But it can be an ugly dispute.
All right, Mo, last question. We don't got a ton of time. This is from Steven. He lives in Winter Park. I was in a car accident where I was the party at fault.
Okay.
What can I do?
Well, you should remember, if you're injured, you still have your PIP or your no-fault benefits. So that's up to $10,000 in benefits to seek medical care if you were injured in the accident. Even if you're at fault, you can still, that's the whole point. There are no-fault benefits, so you can still go get checked out and get the medical care you may need. Beyond that, of course, you want to put your insurance on notice and cooperate with them fully. If there is a claim from anybody else in the accident, typically your insurance company is going to handle it as long as you put them on notice timely. They can deny the claim, though, if you don't give them timely notice or if you're served with a lawsuit and you don't provide it to them. So it's very important to make sure you give them that information in a timely manner.
All right, Mo. Good show today.
Absolutely.
I think we answered a lot of questions.
Lots of fun as always.
Yeah, if you got questions, send those to ask@DeWittLaw.com. We will try to get to them next week. And thanks again for joining us on the DeWitt Law Review, and we'll see you next week.
So I still can't believe how many times people ask me, how do you get paid on accident cases? Well, we work on what's called a contingency fee. So basically, we only get paid if you win. If we recover money for the injuries you sustained in an accident, we get a percentage of that. Usually that's a third pre-suit or 40% after a lawsuit is filed if the other side denies liability. It's a pretty standard rate in the state of Florida, but again, we only get paid if we win the case. Otherwise, it does not cost you a dime.